and witnesses. I commend this bill to the House.
I call Andrew Little.
Thank you, Mr Speaker. It's a pleasure to rise and take a call on the Criminal Procedure Legislation Bill. Mr Speaker, this, as my colleagues have pointed out, is a technical bill. I'm not quite sure what bill the last speaker was referring to, because I don't see reference to the reduction in the number of prisons and the various other things that he talked about, because that is not provided for in this legislation. And indeed, this government is going in the opposite direction and building big prisons, very big ones. The Wirri prison, for example, they might have closed down a couple of older prisons, but the prison population under this government looks like it has a very healthy future ahead of it, the way that it is going. But, sir, this bill is very technical, as I said before. It does simple things like replaces references to the word crime and changes it to offence, because we now have offences under legislation and we don't just have crimes. That provides for some sort of flexibility. It also clarifies what an imprisonable offence is for a body corporate. This is potentially very important. If I am fortunate to have my corporate manslaughter bill drawn from the ballot this week or at some point in the future, or if indeed well-drafted bill, well-crafted bill I would describe it as, it goes beyond just drafting, it's been crafted. And if indeed this government responds seriously, as it should, to the Royal Commission's report on Pike River, and it itself introduces a corporate manslaughter bill, then this legislation here, when it describes an imprisonable offence and describes what it is for a body corporate, then it will make sense. It goes on to clarify the requirements of charging, the requirements for charging documents, which, as I understand it, used to be called informations. But for charging documents, that actually set out crimes or offences that are being pursued, and particularly in relation to private prosecutions brought by an individual, as opposed to private prosecutions brought by a body corporate, which of course can happen now, at least under the Health and Safety and Employment Act, because of the changes that the previous Labor government made, where the Department of Labour declines to prosecute, then either an individual or a union can take that prosecution. So this technical legislation will assist that. It corrects a number of numbering errors in various pieces of criminal justice legislation, and it clarifies the jurisdiction in relation to offences on aircraft and ships, extending the jurisdiction but providing a defence that if you're a citizen of another nation, then if the offence is committed in that airspace or shipping space, then you can have a defence if the New Zealand offence is not an offence in that jurisdiction. So very helpful in that regard. One might have thought things that ought to have been thought about in were the previous bill or legislation that this covers were more carefully drafted. And so this bill does highlight the need that when we are considering criminal justice legislation in particular, that we do get it right. Because if there is one thing that represents the high water mark of what this House does in terms of taking away a citizen's liberty, in terms of the power to incarcerate, or giving judges and the criminal justice system the power to incarcerate and to punish and to penalise, then it is incumbent on this House performing those tasks and passing that sort of legislation to get it right. And it's for that reason two things are required in that regard. One is that we take the proper amount of time to do that, so that legislation that punishes, legislation that imposes penalties, whether it's fines or whether it incarcerates, that legislation must be given the proper consideration and time by all parties, by all members, both in this House and in the Select Committee process. And that the House must give due consideration to the submissions it receives from organisations and from citizens, whether it's the New Zealand Law Society, whether it's those with a criminal record who we hear from time to time. Then this House must give proper consideration to what those interested parties have to say when it comes to this sort of legislation. But the second thing that it does, sir, that it draws attention to is the need for, at least in relation to criminal justice legislation, for a greater degree of bipartisanship or multi-partisanship. That when we are discharging our responsibilities as parliamentarians and passing laws that have what can only be described as the most deleterious effect on citizens. That is to say, effects that are about imprisoning, that are about depriving people of liberty, admittedly under due process, then that is something that there actually ought to be a high degree of collaboration in between parties in this House, because that sort of legislation will come under intense scrutiny by the judiciary, as it should, and the judiciary will always be looking for the true and proper intent of Parliament, and will be wanting to know that Parliament has taken that sort of legislation seriously. When it comes to passing sentence, I mean, it's one thing to secure a conviction under legislation that sets out offences, but when it comes to passing sentence and putting citizens through the criminal justice procedures, then the judiciary needs to know that Parliament has given proper and due consideration, taken it seriously, understood the magnitude of what Parliament is doing and what we are demanding of the judiciary and what we are subjecting citizens to. Then it's very important that we get that stuff right, and we can only do that properly and seriously if we are working in a more collaborative approach to do it. There shouldn't be the sort of party political division that there has been in more recent years over this sort of stuff. And we certainly don't want to see the type of knee-jerk reactions that we've often seen to issues that have been raised, usually in the community. Yes, there will be individual cases, court cases, criminal cases, that will give rise to concern. That's a normal part of democracy. But it should not lead this House to respond piecemeal and in a knee-jerk way to those particular concerns, as we've seen, for example, most recently in the Jurors' Amendment Bill, which deals with the juries' lists, because on one case, on one occasion, a defendant saw or got access to the details of a jury list and made personal contact. We shouldn't be seeing knee-jerk reactions to that sort of instance. So it would be desirable, sir, if, as we've seen a greater degree of cooperation over this sort of correcting legislation, no pun intended, is that there is we demonstrate that we are capable of working sensibly and cooperatively together to make sure that our criminal justice statutes are the best we can possibly do, and are a model of all other legislation, not just from this House but across parliaments in the Commonwealth generally. Sir, the message is that we should never take criminal justice lightly, because it is serious legislation, it has serious impacts on our citizens, and when we come to deal with them, as we do in this legislation, as we correct things that have been legislated for incorrectly, perhaps even imperceptibly in the past, that we are bold enough and big enough to correct those mistakes, do so in a cooperative spirit, but learn the lesson that we can avoid having to do this type of rework if we actually get it right in the first place. And we will get it right when we give ourselves enough time, give it due consideration, and work properly together in a proper process of collaboration and harmony that is not only fitting for the legislation but fits the season as well. Thank you, sir.
Call Mike Sabin.
Thank you, Mr. Speaker.